We are joined right now by Aryama Sundaram, a senior advocate, Supreme Court lawyer. My first question, sir, is what I asked Dr. Singhvi as well. Would you reckon the Vice President was out of line with the comments that he made regarding the top court of the country, keeping in mind that his position is largely ceremonial, constitutional?
From what India was meant to be, what the framers of the Constitution expected things to be, and what was anticipated was that governors would be statesmen who would be above any politics, who would not be playing to political masters, as were speakers of the legislature in those days, answerable for the dignity of the House and not answering to political masters. It was with that intent that the framers of the Constitution gave the governors their powers, gave the speakers of the legislatures their powers as masters of the legislature. Unfortunately, over a period of time, and I'm sorry it started as early as in the 1970s, both the governors and speakers became nothing more than puppets of their political masters, of the ruling party and power at the given time who had appointed them, or of the majority house of whom they were the representative and therefore became a speaker. Now, when you look at it that way, what do you do? Because the framers of the Constitution expected these people to act in accordance with the Constitution and to discharge their functions in accordance with the Constitution. Now, this is where the court comes in. I don't think it is a power exercise by the court. I think it is a discharge of its responsibility that the court has had to pass the kind of judgment that it did. The reason being that if a governor does not discharge his functions under the Constitution, it becomes the duty of the Constitutional Court, which has been charged with the function of ensuring compliance with the Constitution, to ensure that every constitutional functionary, every statutory functionary functions in accordance with the Constitution. So I believe that the judgment of the Supreme Court was absolutely necessary and correct in the facts of the matter, where a governor of a state has just stalled all progress of the state by acting in a manner which the Constitution does not envisage him to act, by not approving of bills, and by doing so, I'm sorry to say, brought the office of governor into a situation, into a position where the court was forced to interfere and in fact had to very clearly say that it is the duty of the governor to act in accordance with the Constitution. If he does not do so, we as a court will ensure that he does so.
So, Mr. Sundaram, from the question that I asked you first, I concur. You do not agree with what the Vice President said, accusing the judiciary of judicial activism, overreach, and you know, where he called out Article 142 as, the judiciary acting like a super parliament.
I said the Vice President is speaking from the expectation of the framers of the Constitution that these constitutional authorities will act in accordance with the Constitution. And he is really stating something which even the framers of the Constitution would have wanted, that the courts would not ever come into the realm of either the legislature or the executive, and that was the basis of separation of powers. So he's talking from a position of that. But please remember that taking an unconstitutional decision is no different than not taking a decision that you're meant to take under the Constitution. Both are equally correctable by judicial review. And what the Supreme Court has done is exercised its powers of judicial review, which has been given under the Constitution, to ensure that these people who have been charged with such constitutional functions act in accordance with the Constitution. And remember, inaction or not acting in accordance with or not acting as you are required to do under the Constitution is no different from acting against the Constitution. And the court has to interfere. And the court rightly passed the judgment that it did.
All right, so Mr. Sundaram, allow me to go point by point. The Vice President called Article 142 a nuclear missile against democratic forces. He's gone on to criticize why it's being used frequently by the Supreme Court. Do you believe this characterization is justified, or is it Article 142 an essential tool for ensuring justice?
Article 142 is to ensure that complete justice is done. Article 142 ensures that the Constitution is complied with and has been given this power to the Supreme Court to ensure that. Should Article 142 be used? According to me, very, very rarely, only when situations will arise which absolutely call for it. So the Vice President may be right in saying Article 142 should not be used in every situation. But in this given fact, in this given case, I think most correctly has the Supreme Court come in. I won't say it is only Article 142. It is also the exercise of the judicial powers of the Supreme Court to direct a constitutional functionary to act in accordance with the Constitution.
But Mr. Sundaram, the Vice President then also argues that the Supreme Court's directive to the President to act on bills within a 3-month deadline oversteps judicial authority, where he's accusing the judiciary of possible judicial overreach. Do you think the Supreme Court has restrained itself?
Well, what the Supreme Court has said in this case is not much different than it has had to say in cases where the Speaker of the legislature did not act in accordance with Schedule 10 of the Constitution with regard to disqualification petitions. Speakers would just sit on disqualification petitions without taking decisions on it and then say judicial review cannot come into play because the court should not interfere with the Speaker's actions. But that, the Supreme Court has clearly said that the Speaker has a duty to act in accordance with the Constitution, has a duty to act in accordance with Schedule 10, and if the Speaker does not act, the Supreme Court can direct him to act. And in those cases, there is a case where the Supreme Court gave a deadline of 3 months. Subsequently, in the Maharashtra case, the Supreme Court gave a deadline of 2 months by which the Speaker was to take a decision. Now, a similar argument was put up there, and that's not much different than what is being said now. The point of the matter is, let's not forget what has happened. Let's not forget that a governor has sat on bills, not for days, not for weeks, for months, and if I'm not mistaken, in a certain case, even for a year, without passing a bill. Now, without approving a bill, without giving his assent. In other words, he brings the entire constitutional machinery to a standstill. Now, is a court meant to sit back and say, oh, we cannot interfere, we cannot give directions, we should allow a situation to arise where there's a complete constitutional breakdown because the governor does not act? I'd say if the Supreme Court did so, the Supreme Court would be abdicating its functions and its duties and responsibilities.
But Mr. Sundaram, the Vice President also questioned the judiciary's authority to direct the President. While the opposition leaders have defended the courts, arguing that no office, including the Vice President, is above the President is above constitutional security. As per you, was the 2-judge bench in the Tamil Nadu case constitutionally competent to issue such a ruling?
To answer you, absolutely constitutionally competent, because one thing we should never forget is that the Constitution is above everyone. The Constitution is above the court. The Constitution is above the executive. The Constitution is above Parliament. It is constitutional morality which has to be protected, and that looms large. And if any constitutional functionary does not act in accordance with the Constitution, there is no amount of protection through separation of powers or Article 145 or whatever else you would bring into play, which can protect constitutional constitutional violation by constitutional authorities. And I say inaction, non-action, stalling by constitutional functionaries is equally a violation of the Constitution. And I believe that what the Supreme Court said was absolutely correct. And especially in the facts of this case, it was absolutely called for.
But all of this also comes in the backdrop of what has been very deep criticism of, the judiciary handling of many cases, be it what we discussed, the cash haul at Justice Yashwant's residence, questioning why no FIR was filed and why a 3-judge committee rather than, the executive is investigating. The question is also, does the judiciary have the constitutional authority to self-investigate such matters, or does the support of the Vice President's claim of judicial unaccountability, because that has brought a debate in society today?
I think this is quite an old situation where any judicial member does not act according to the court, or his conduct as such that has raised certain questions which has to be inquired into, that the judiciary itself, through a high-powered judicial committee of very senior judges, usually investigates the matter. This is nothing new at all. This is something which has been done in the past. And in fact, even when you move for impeachment, let us say, of a judge, the first stage after the admission of the impeachment petition is that a panel is set up by the Chief Justice, consisting of a judge of the Supreme Court, a Chief Justice of a state, and an eminent jurist, to go into this and to give their report as to whether a case for impeachment is in fact made out. So the judiciary looking into these affairs is not wrong. Now, let's not forget something. The judiciary's duty is to look into matters like this. If there is impropriety, alleged impropriety in the judiciary has a duty to look into it first. And I think what is being done now in this case is really not a departure, but is something which has been done in the past in other cases also.
All right, appreciate you joining us, Mr. Sundaram. Thank you for taking the time out.